Karnataka High Court, Mr. K.G. Raghavan, Senior Advocate, the Chairperson, Honorary Secretary and members of DLN Foundation, Mr. DLN Rao himself, Justice Shyam Prasad, members of the bar, ladies and gentlemen. It gives me great pleasure to participate in the discussion on judicial independence and accountability organized by DLN Rao Foundation while commemorating Sri H.V. Datar birth centenary. During the early years of my practice, one advocate who was held in awe was the inimitable Mr. H.B. Datar. He had matters virtually in every court and will glide in and out of courts, finishing cases in a jiffy. I remember his distinct style. All the files of his would be like this, folded, not the Bangalore style. He will walk in, what is tied, he will just take the tape out and slip it on the coat sleeve and start arguing. And many a time he would finish before he opened the file itself. But the greatness was, he was precise, he knew his law, he argued briefly but with clarity. He knew which point to urge before a particular judge to get the order. Normally and routinely, he walked away with orders of admission and interim orders. DLN Rao and Anuradha were trained by him. I am sure they have continued in the same tradition of winning cases. I am also happy that DLN Rao Foundation is serving the bar by encouraging and promoting ethical legal practices and excellence in the field of law by holding seminars, lectures, and also by distributing scholarships. Today's topic for discussion, judicial independence and accountability, is of great relevance and importance to the judiciary, rule of law, and functioning of democracy. Justice Commissioner Rao, a sitting judge, very diplomatically did not either criticize the system or support the system, because people will think if he supports, oh, he is a judge. And if he condemns, oh, how can he as a judge? But he gave good advice that should be followed by the members of the bar and the judges. As far as Raghavan is concerned, I have a problem. I thought Raghavan will say something against judiciary and all that, and what I should say in defense of the judiciary. I had prepared myself to answer some of the accusations against the judiciary. But Bandmel il Gotaitu, he had taken wakalat for the judiciary. The best possible arguments favoring accountability, independence, judiciary have been put forward by him. So I'll ನೋಡ್ತೀನಿ ಎಲ್ಲ ಮುಗಿದೇ ಹೋಗಿದೆ, ನಂದೇನು ಹೇಳೋದೇ ಇಲ್ಲ. But something you should be retained by the other side to find fault with the system also, Mr. Raghavan. I'm sure you will do it on another occasion. First, I will say a few words about judicial independence, and as I said, most of it he has covered. I will therefore go to the fringes and try to touch upon things normally. First is, what is independence? Judicial independence. It has been put beautifully in the first judge's case. This is what the court has said, and I quote. But if the judiciary should be really independent, something more is necessary, and we have to seek in the judge himself and not outside. A judge should be independent of himself. A judge is a human being who is a bundle of passions and prejudices, likes and dislikes, affection and ill will, hatred and contempt, and fear and recklessness. In order to be a successful judge, these elements should be curbed and kept under restraint, and that is possible only by education, training, continued practice, and cultivation of a sense of humility and dedication to duty. This is the crux of independence. In Madras Bar Association, to which I was a party, the Supreme Court clarified judicial independence thus, I quote, "Independence is not freedom of a judge to what they like or he likes. It is the independence of judicial thought. It is the freedom from interference and pressures which provide the judicial atmosphere where he can work with absolute commitment to the cause of justice and constitutional values. It is also the discipline in life, habits and outlook that enable a judge to be impartial." This is what it was said in Madras Bar Association. Then we have the fundamental rules, the Bangalore Principles of Judicial Contact 2002. It summarized the principles relating to independence of a judge, and I will give two of those principles. The first is, a judge shall exercise judicial functions independently on the basis of judge's assessment of the facts and in accordance with the conscientious understanding of the law, free of all extraneous influences, inducements, pressures, threats or interference, direct or indirect, from any quarter or for any reason. This is what the Bangalore Principles stated. And it also said, a judge shall not only be free from inappropriate connections with and influenced by the executive and legislative branches of the government, but must also appear to a reasonable observer to be free therefrom. These are the two principles I would like to say. Now, the principles are clear that courts should be independent, judges should be independent, judiciary should be independent. Everybody agrees. Are we doing, or we means the judiciary? Of course, I cannot now say as a part of the judiciary, but as a past member of the judiciary, I feel I have the right to say that. Whether judiciary itself, when I say judiciary itself, I am referring to the higher judiciary, that is the Supreme Court and the High Court. Are they doing what is necessary to maintain the independence of the judiciary in this sense? We have only 33 judges in the Supreme Court. Maybe we have, I do not know how many, nearing about 900 or 1,000 High Court judges. We have nearly 20,000 or more judges of the district judiciary. If at all the independence should be developed, it should be developed in the district judiciary. Is the High Court and Supreme Court doing what is required to create, nurture that independence in the subordinate judiciary? To be independent, judges should feel independent. The question I ask to every High Court judge and the Supreme Court is whether the members of our district judiciary are feeling in their heart that they are independent. Unfortunately, I have a feeling that they do not have the feeling that they are independent. There are very simple things that can be done by the High Court. I am not talking about principles and guidelines and high-level discussion. Simple things that can be done by the High Court and by the Supreme Court to improve, to instill a sense of independence in the subordinate judiciary. The word subordinate itself I hate. We will call it as district judiciary. The first thing, I have noted one or two, 3 or 4 points. I will just refer to him. the Supreme Court and High Courts, while disposing of appeals or revisions, routinely direct time-bound disposals or priority in hearing. While doing so, they do not take note of the fact that there may be several older matters or more urgent matters requiring the attention of the judge. The directions to dispose of time-bound matters interferes with the independence of the trial court judge to make their own assessment of the comparative urgency of the cases on their board and prioritize deserving cases. Instead of routinely issuing time-bound directions to the trial courts to take up and dispose of certain case expeditiously or directing that hearings be held day to day, the higher judiciary should merely observe about the need for early disposal of the case so that the trial judge still has the independence and discretion to organize and regulate his board. Many judges have complained. We have thousands of cases. We have listed important cases in the sense older cases because we are directed to dispose of older cases. And then a matter goes before the High Court or Supreme Court, argued very vehemently like advocates like DLN and Raghavan. The court finds that there is no merit in the case. Then the senior lawyer does not end there. He wants some relief. He says, will you kindly direct that the matter may be disposed of expeditiously? And the judge feels, I am anyhow rejecting the petition, let me at least do this thing. So he keeps on directing case after case in a case where there is no urgency when compared to the hundreds and thousands of cases which are lying for 10 years and 20 years, that please dispose of this, not please, direct that we dispose it of by holding trial. So every day when you take the cause list of a district judge, he does not have the independence of regulating his board. He has to take the cases which have been directed by the High Court and Supreme Court. If he fails to do so, he is in contempt. Is this the independence we want for the district judiciary? The High Court and Supreme Court can say, this case requires priority, but you confirm it. You feel that it is so, you do it. That independence should be given to the district judiciary. We are not giving it. Second, the trial judges dread unwarranted remarks by the high courts about their conduct or about their decision without giving any opportunity to the district judges, district judiciary members to explain. In spite of Supreme Court repeatedly observing that higher courts should not pass objectionable remarks against a lower court judge merely because the higher court finds the decision to be erroneous or not agreeable with its reasoning. The high courts and Supreme Court should stop demoralizing judges by derogatory and objectionable remarks, as for example, by directing that the trial judge concerned should be sent to Judicial Academy for orientation. This is written in the judgments. The High Court judges write, some of them, I'm sorry to say, write that send the judge to Judicial Academy for training. Instead of making such in fact, it is, of course, I should not be saying, the same thing was said about some High Court judges by the Supreme Court also. They extracted the entire judgment and showed that it makes no sense. And of course, they could not ask the High Court judge to be sent to the Judicial Academy. But what I am saying is that demoralizes the judge. You can set aside the order, and on the administrative side, you can request the Chief Justice to look into, to see what can be done to improve this thing. Never publicly humiliate a judge. How can he be independent if you do it? This is something which can be done by the judges. The third, judges should be freed from protocol duties and deputation to posts which do not involve adjudicatory functions, but involves working in close proximity with members of the executive or legislature. To maintain independence, judges will have to maintain a distance from lawyers, litigants, politicians, and members of the executive and the legislature. But their duties and functions with reference to legal services require organizing legal awareness and legal literacy programs and lok adalats. For conducting such programs, members of the cooperation and assistance from the members of the bar, the district administration, police, and local elected representatives. Such dependency upon the bar, district administration, and elected representatives robs judges of their independence. My appeal is, why do you appoint a judge? You go to any state, any place of importance, a judicial officer is a protocol officer for the visiting judges. The visiting judges are not kings and rulers. Why do they require the attendance of a judge? You will find it in every place. This should stop. How do you expect a judge to be independent if he is doing protocol duty for other judges, or he is posted in the government as a law officer to find out, to give opinions, to work closely with the executive? The independence goes. I am not saying that there should not be, but they should permanently opt and go to the law department or whatever it is. If he is a judge, he should be independent. If he has to be independent, he should not get in touch with executive and legislature. You have to do that to maintain the independence of the judges. Now, this also again for the High Court judges too. The tradition that local judges should be in attendance when judges of the Supreme Court or High Court visit any place should be discontinued. The unwritten rule that members of the district judiciary should wear a suit and tie even if it is very hot when they meet the members of the higher judiciary or attend functions participated by the judges of the High Court and Supreme Court should be discontinued. The practice of Supreme Court and High Court judges being addressed as my lord and your lordship by judicial officers even outside the court should be discontinued. A sense of equality that all judges belonging to the judicial fraternity are equal except in the exercise of jurisdiction should be nurtured. The higher judiciary should not give room for a comment that though feudalism has left the country, it has continued in the judiciary. Justice Voka in a recent I'm sorry, I get always confused. Is it Voka or Voka? Okay. Justice Voka in a recent speech referred with anguish that during the last 75 years, we have committed the fundamental mistake of neglecting our district judiciary by describing them as subordinate courts or lower courts. This is all I want to say. These are small things which the High Court and Supreme Court can do. It does not require a law. It requires an effort to treat the judges of the district judiciary with respect, with equality, with fraternity, so that they will develop the independence to give justice. If they are not independent, if they feel subservient to the High Court and Supreme Court, they feel subservient to the government also. They are always afraid. Nowadays they are afraid of the media also. Whether a bail is given, what the media will say. If the bail is refused, what will they say? What will the High Court say? Therefore, a stage has reached in many cases, many subordinate courts think, why we should give bail, you go to High Court. And High Courts also now started thinking why we should go and let the Supreme Court give. And therefore, we have a situation where Indian Supreme Court is only Supreme Court where most of the time is spent on bail matters rather than on constitutional law matters. This is the unfortunate thing that we are having. We do not require 33 judges if you are going to spend 90% of the time for bail matters. We require only 9 judges speaking with one voice so that there will be uniformity, consistency in law. That is where independence comes. That is where accountability comes. Therefore, I would with this quotation, my favorite quotation from Justice Cardozo, I will complete my comments on independence. This is what Cardozo said. I quote, "The judge, even when he is free, is not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his own ideal of fairness and justice. He has to draw his inspiration from the well-consecrated principles. He is not to yield to spasmodic sentiments, to vague and unregulated benevolence. He is to exercise discretion, informed by tradition, methodized by analogy, disciplined by system, and subordinated in the primordial necessity of order in social life, wide enough in all conscience, is the field of discretion that remains. Therefore, judges, when they are supposed to be independent, the independence is not the independence to do what they want. It is the independent to support, the safeguard the citizens. That is the independence they have, and they should not forego that. Let me now go to judicial accountability. Due to certain recent events, judicial accountability is currently a matter of hot discussion, and a lot is being said about the lack of credibility, accountability, and transparency in the appointment and functioning of the members of higher judiciary. It's a very touchy subject. I don't want to say anything, but Anuradha also mentioned it as if it is a sin. She said 69% of the judges of the Supreme Court or High Court, whatever, I do not know, she mentioned, are from the families of judges, from the families of advocates. How can it be? Is it not an injustice? Is it not something that affects the credibility of the institution? I mean, I do not understand this view. She has not expressed it. She has referred it as a statistic extracted. Now, if a doctor's son becomes a doctor, nobody finds fault with it. If a chartered accountant's son becomes a chartered accountant, nobody finds fault with it. If a businessman's son becomes a businessman, nobody finds a fault with it. If a politician's son becomes a politician, nobody finds a fault. But if a lawyer's son or a judge's son becomes a judge, it is pointed out. We have a great judge here sitting. His father, my close friend, was one of the best judges. No, why am I saying? What is wrong in judges and lawyers' sons becoming judges? Naturally, when lawyer's son, at least if he has a couple of sons, or at least 3, 4, 1 or 2 would become lawyers. Nothing wrong in it. Here is another great judge's son, but of course he did not choose to become. Judges' children become judges. Why not? Is something that has nothing to do with accountability. Then, again, Justice Oak's recent speech I was reading, he says, judges have no right to say that common man has faith in judiciary because out of the 4.5 crores cases pending, 1 crore cases are more than 10 years old. He says, how can you say that people should have good opinion of judges, judiciary, trust with the judiciary? See, he also points out the day is not far off when an accused who has languished behind bars for a decade before being declared innocent and let off, posing this question to the judiciary. I quote the question. When the court has found me that I am innocent and that there is no evidence against me, why is it that I was detained for a decade or more? How am I and my family going to be compensated for the loss of the valuable part of my life and liberty? Why I am saying this? If you are talking about accountability, don't talk about accountability in appointments. Let us talk about accountability in doing work as judges. You find out, you see, if a court has more number of cases, the members of the bar should represent to the person in charge, this court has more cases, that court has less cases, please correct it. If a judge has reserved more number of cases without delivering judgment, bring it to the notice of the... In fact, I have a feeling the Chief Justice should have a system where in regard to every judge, in front of every court, you have a board showing total number of cases that are reserved for judgment and how many are above 3 months or 4 months. You do it and automatically the judge's work improves because of pressure of work, because of various circumstances. He may not be able to attend to a case. But if you have this hanging sword, then he will work. That is, we have to find methods of bringing in accountability rather than merely complaining, saying that accountability is necessary, there is no accountability is there. The second thing, what is accountability? See, that's why I was mentioning our Supreme Court is the only court having nearly 3 dozen and most probably maybe increased even more, working in 15 benches or 16 benches and speaking with 16 voices. Should we not have one constitutional court with 9 judges, 10 judges who speak with a single voice? Let it be howsoever wrong, but let it be wrong with a single voice. Illa. And the judges, what is happening is, I am told by lawyers, he is very strongly relies on a decision and refers to it. The other side stands up and very strongly relies upon another judgment of the same court taking a completely contrary view. Why should these contradictions be allowed? Why is it nothing is done by the courts to avoid inconsistencies? Why is it judges, when a decision is cited, and if it is inconvenient, in the sense, the judge feels that the decision should be this, the judgment cited is not to his liking, he ignores it. Now, if you ignore a decision and then render a decision, then we have 2 decisions. If you have 2 decisions on the same view, a case which can be argued in 15 minutes takes 2 hours. And imagine, if this is of the Supreme Court, High Court judges are nervous. How can we, idralliro collegium-nalliro judge, idralliro collegium-nalli iವರು ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೋ, ಅವ್ರು ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೋ ಅಂತ. ಅದೇ ಥರ High Court judges, if there is 2 inconsistencies, poor fellow, a district judge, what will he think? Next he has to be promoted as a High Court judge, or he may be posted somewhere because a judge whose judgment he did not follow might not like it. The accountability is in ensuring that there is consistency in judgment. There is uniformity in judgments. That's why we have the great system of precedents. Why are we not following that? And if they are not followed for some reason, many a time it is not possible to bring to the notice of the court a particular judgment because the lawyer might have missed it. Immediately have a system to set right that whenever there is an inconsistency, let all those cases be posted before a larger bench and the inconsistency be removed so that the lawyers can work and the clients, the citizens can regulate their work. Nowadays, they cannot with certainty regulate their affairs because you have a legal position this and legal position that. This is where accountability is required. Accountability in regard to appointments, accountability in regard to other larger aspects, we will leave it to the larger people, bigger people to do. Let the judges, the High Court judges, the sitting judges do what is possible and remove the inconsistencies, avoid inconsistencies, and you will have a credible judiciary. You will have a judiciary in which there can be trust. Therefore, all that I say, I appeal, of course, fortunately or unfortunately, we have only 2 sitting judges of the High Court here. I am sure that somebody will tell the other High Court judges also who may think, you even reader ಆದ್ಮೇಲೆ ಬಂದು ನಮಗೆ lecture ಕೊಡೋಕೆ ಬಂದು. See, many a time it has happened to me when I wanted to say this, somebody would come very respectfully and say, sir, ನೀವಿದ್ದಾಗ ಏನು ಮಾಡಿದ್ರಿ ಸರ್ ನೀವು? I know I did not do anything. Then, if everybody who did not do anything cannot give advice, there will be nobody to give advice. At some time, people like us, who are judges, who could not do something, will have to share their failure to do something to the next generation so that they can do something. I feel independence, accountability are all with the judges. Thank you.